continue to help you. So again, our training today is brought to you by our partners over at San Bernardino Workforce Development Board. And today we are so pleased to be joined by the power duo Desiree Thomas, Business Services Technician, and Carmela Giliberto, Business Services Specialist, who are both here to share more about the resources available to employers like you. Good morning, Desiree.
Good morning, Anna. Thank you. And thank you everyone for joining us for another one of our monthly workshops brought to you by the always engaging speakers of the CEA. As you may have seen in the flyer, Workforce Development offers a wide range of services to support small businesses. We have 3 America Job Centers here in San Bernardino County, one in San Bernardino, another in Rancho Cucamonga, and one in the High Desert in Victorville. We also host multiple job fairs throughout the county, so if you have any hiring needs, please let us know. One of our most popular services is the On-the-Job Training Program. With the help of WIOA funding, we can assist businesses with their hiring needs by reimbursing 50% of wages paid up for up to 3 months while training a new employee. If you're interested in taking advantage of this program, please reach out. We'll love to help. And as you know, we also host these monthly business and HR workshops like the one you're attending today. Be sure to register early for our next month's session on how to be a leader, not a boss, happening on August 20th at 10 a.m. I'll put the link in the chat shortly. Next, we have Carmela, our business service specialist. She will walk you through some of the great opportunities and services we provide to help businesses grow.
Thanks, Desiree. Good morning, everybody. As a business service specialist, I work with business consultants who help businesses in need of funding for needed business improvements. Think about incumbent worker training, social media marketing, leadership training to increase productivity and therefore prevent layoffs. If you are a business with at least 10 employees and need help to retain your employees and prevent layoffs, let me know. We recently rolled out an exciting transitional job program. Think of this like a part-time paid internship where the county is actually the employer and we will provide the business with candidates for your consideration for up to 320 hours. So if you need additional help, it's a win-win. Let us know. That way you're giving our unemployed job seekers the opportunity to gain work experience. Take advantage of our complimentary HR hotline, guys. It's 1-877-282-3763, as you see in the flyer here. We also have an employer toolkit where you can have access to various resources, as well as links to all our partners in San Bernardino. So save our website, workforce.sbcounty.gov. This way you can access our calendar of our future job fairs and our workshops like this, and follow us on Eventbrite. If you're interested in any of these services we mentioned, we'll put our information in the chat. Reach out to us. So I'd love to make an appointment to discuss them in further detail at your convenience. Thank you so much for your time. And without further ado, I'll give you back to our beautiful Anna and our fabulous speakers, Astrid and Eliseo from the CEA.
Awesome. Thank you, Carmela. Thank you, Desiree. Everything that all of you do to serve employers in your area. It's awesome partnership that we've had for a really long time with your organization. So now I'd love to introduce our trainers today. We have Eli Nunez and Astrid Servin. As Carmela just mentioned, these are 2 of our amazing HR directors who you may have the pleasure of working with if you call into that complimentary HR line. So you're in great hands. So good morning, Eli.
Good morning, Anna. Thank you for that great introduction. We're pretty amazing, aren't we? I'm kidding. No, but thank you to Workforce Development Board of San Bernardino, too, for partnering with us. And just want to remind you all, of course, you've heard it a couple times. We have that hotline for you. So if you have any questions about the presentation today, any questions about anything HR related, or if you have a situation you just want to talk through with one of us, give us a call. We'd love to hear from you. We'd love to help out. Our goal as California Employers Association is to make sure we provide you with peace of mind. We know HR is pretty complicated, especially in California. So we are here to help. We like to say that we keep the human in human resources. So when you call us on that hotline, you'll always get a live person, whether it's, a receptionist, Jen. She'll pass you on to one of us HR directors that can help with hopefully any situation. I mean, we have over a century of experience between all of us combined. And CEA's been around for almost 90 years, so chances are whatever you present us with, you won't knock us back on our seat too much. It's something we may be familiar with or have dealt with, so hopefully it's something that we can help you get through. A little bit more that I'd like to add, though, is that even though we will talk about new labor laws and changes and that sort of thing in this presentation, this is not legal advice. We're not attorneys, we're not lawyers, so this presentation is more for educational purposes to talk about best practices, talk about the changes, talk about what you can expect. But again, it should not be taken as legal advice. We do recommend if you have any questions of a legal nature, you consult a licensed attorney so they can better help you in that arena. And if you need help with that, we have a couple we can recommend as well. So let's jump right into what we'll be covering today in this presentation. I'll take the first half, so if you have any questions about the subject matter, about what I'm talking about, Aster will be in the Q&A, and then about halfway through, we will switch places where she will be presenting, and I'll be in the Q&A to answer your questions. So some of the topics we'll cover today, of course, are wage increases, updates to OBA, the One Big Beautiful Bill Act, which we refer to as OBA because One Big Beautiful Bill is a mouthful and a little corny, to be honest with you. So we'll just call it OBA. We'll talk about artificial intelligence in the workplace, best practices, some things we recommend as well, and some annual notice and training obligations, as well as developments on the federal level and new case law. So it's important to remember when laws come out, employers and employees have to abide by the law as it is passed by legislature, signed by the governor, but then we also have to see how the courts interpret it, and that could change how it applies. That's why it's important to take a look at those new case laws. So we'll jump right into the wage and hour portion of our presentation, just because this tends to be pretty impactful, right? As far as impacting our bottom line, impacting our businesses, impacting our employees. So one of the things we'd like to touch on are some of the local minimum wage increases. We'll talk a little bit about the healthcare minimum wage increase as well. And there's been the change to IRS mileage. In other words, if you have employees drive their personal vehicles for business purposes, you have to compensate them for mileage. Usually that increase only comes at the end of the year. However, we've seen a mid-year increase this year, so we'll talk about that as well. And as I mentioned, we'll talk about OBA, how it applies to tips and overtime. One of the big selling points of OBA when it passed or when it was implemented last year was no tax on tips, no tax on overtime. We'll review what that means and how it affects you as employers. So to start, we'll start with the minimum wage, of course. And just to recap, I mean, at the start of the year, the state of California's minimum wage increased to $16.90 per hour. And if you're thinking to yourself, well, gosh, didn't it just increase last year and the year before? That is true. There's been a lot of increases lately. Reason for this goes back to when Jerry Brown was governor. There was a law passed that stated that whenever the cost of living or inflation exceeds a certain amount, it automatically triggers a minimum wage increase. So that is the case again. Those conditions were met last year, meaning that minimum wage increased to $16.90 statewide. And that is for non-exempt or hourly employees, but as you know, that does tend to have a ripple effect and affect our exempt or salaried employees, such as managers, HR generalists, that sort of thing, right? Anybody that's on salary or exempt. So the law says that those exempt employees have to meet a minimum salary requirement of 2 times the hourly minimum wage. So you take that $16.90 number, you double it, you multiply it by 2,080 hours, and you come up with that rather large number you see on the right-hand side there. So if you have any exempt employees, they should be making at least $70,304 a year to maintain their exemption. Now, there are some different minimum wages for different industries, and as I alluded to earlier, in different areas as well, but one that comes to mind is the fast food minimum wage. This was very highly publicized when it passed. So what that means is anybody that works in a fast food chain that meets the required conditions has a minimum wage of $20 an hour, and that also has that ripple effect on their exempt employees, meaning that they have to earn the minimum of $83,200 per year. So if you have any fast food managers, fast food you know, generalists or anything like that that are salaried, they have to make at least $83,200 per year. Now, we do have some participation in this webinar, so I got a question for you, and then we'll run a poll right after this. Which minimum wage applies? In this case, if your company is headquartered in Stockton, California, which follows the state minimum wage of $16.90, but you have non-exempt employees working 3 days in Stockton and then 2 working days at a conference in Oakland, which has a higher local minimum wage, what is owed? How do you pay those employees when they work in different areas with different minimum wages? So we have a poll that I will, let me find it and launch it here for you. So what is owed to those employees working in different areas? Do you have A, you can pay $16.90 per hour for the whole week because you're headquartered in Stockton. You must pay $17.34 for the whole week because that's the highest rate. Or you can pay $16.90 per hour for work performed in Stockton and $17.34 per hour for work performed in Oakland. So let us know what you think. I see the poll numbers jumping up, so thank you very much for your participation there. And I see an answer popped up here in the chat. That is perfectly valid as well. Thank you very much for participating and answering too. All right, so it looks like we have quite a few participants here, a couple more trickling in, so I'll give it a couple more seconds before moving on. Again, let us know what you think about this one, A, B, or C. How do you pay those employees? And this applies to a lot of people because, sometimes you have different locations or you have different people travel to cover, or maybe the nature of your work means you have to travel to clients' homes in different locations. So, that could mean that different minimum wages may apply in those situations. All right, we'll go ahead and end this poll now and kind of share those results. So the majority of you did say that you have to pay $16.90 for the work performed in Stockton and $17.34 for the work performed in Oakland. Some of you had the other two answers there, $17.34 for the whole week or $16.90 for the whole week because that's what's owed. The thing to keep in mind here is that you always have to pay at the minimum wage at the location where the work is performed. So in this case, the correct answer would be C. You can pay $16.90 for the work performed in Stockton because they're under the state minimum wage, but you have to pay the higher minimum wage of $17.34 for any work performed in Oakland because they have a higher local minimum wage. So thing to keep in mind is when it comes to minimum wage and some other protections, the state can establish a floor or a lower limit to what it is, but local municipalities or local cities, sometimes different trade groups can establish a higher minimum wage depending on what they believe is fair or necessary in those areas. So in this case, the correct answer would be C. You pay $16.90 for work performed in Stockton, $17.34 for work in Oakland. Some of you said B. You could pay $17.34 for the whole week because that's a higher rate. That's not required, but that is correct. And if it's a salaried employee, that does not matter. Salaried employees are paid for the hour by for the entire year by salary, and they are only subject to the calculation based on the state minimum wage, not on the local minimum wage. So in that case, if you have a salaried employee earning that $70,304 minimum, they would be paid the same regardless of where the work is performed. Now, this is important to keep in mind because across the state of California, there are over 40 local minimum wage laws beyond the state minimum wage and counting. They seem to be increasing every year. It just used to be some of the larger cities or some of the larger metropolitan areas had their own minimum wage, but now we're seeing additional laws come in that not only affect minimum wage, but there's also paid sick leave, predictive scheduling, flex time. There's also some that are based on the industry. So in Southern California, there's certain hotel industries in certain locations that have a higher minimum wage than the rest of the state or the rest of the city. So keep that in mind. And the important thing to know is that that minimum wage is based on where the employee is physically working. So if you have employees that work remotely, work from home, and they're hourly non-exempt employees, make sure that they're earning the correct minimum wage. We saw a lot of this happen back a couple of years ago when we had the pandemic. A lot of employees moved around, some moved out of state or moved to different cities because they were working remotely, and employers weren't aware of it. So, they weren't sure what the correct protections were. So it's always important to know where your employees are performing their work. And also, if you're in an industry where your employees travel to different locations, I always give the landscape example. If you have landscapers that travel from your headquarters to different cities or to different towns, make sure you know where they're going and whether there is a different minimum wage in those locations. And of course, we do have a little link there on the bottom, a bit.ly link that has linked to a cheat sheet we put together with different minimum wages throughout the state. Now, some notable minimum wages that we've seen come across, and these take effect on July 1st, halfway through the year. Up in Northern California, we have Alameda, Berkeley, Emeryville, Fremont, Milpitas, and the city of San Francisco. Southern California, the city of Los Angeles County, Malibu, Pasadena, and Santa Monica all have minimum wage increases kicking in on July 1st in a few places. And there's also some hotel industry minimum wages that are occurring on July 1st. Glendale, the city of Los Angeles, Santa Monica, Long Beach, West Hollywood, and San Diego. That is a new one for us this year. Thing to keep in mind about that San Diego one too is it also covers event centers and amusement parks. So if you are an employer in those areas, then be aware that that local minimum wage is increasing. Or if you're in the hotel industry, be aware of what that local minimum wage is in case it does affect you. All right. Now, I also talked about or mentioned the healthcare industry, and healthcare has its own minimum wage established as well. Now, what's different from healthcare than, say, the fast food minimum wage, for example, and is that healthcare decided to take a more gradual approach to that increase. So the goal of the healthcare minimum wage is to make sure that everybody's making at least $25 per hour in that industry. But rather than just say, starting next week or next month, everybody's at $25 per hour, they decide to do gradual increases. So a little bit each year to kind of lessen the impact and allow some adjustment, if you will. Now, this minimum wage for healthcare came into effect on October of 2024, and it kind of set the tone for what the future increases would be. And this applies to most medical facilities, right? Hospitals, residential settings, physicians groups, outpatient clinics. We also have a bit.ly link for that has more information on it. And again, that applies to most employees at those covered facilities. So we're not just talking about nurses or medical assistants or anything, but anybody that's working at those facilities. And again, these are more gradual increases. So rather than say everybody in the healthcare industry has to make this much, um, it's going to be different based on what kind of facility you work at. And just like the fast food minimum wage, this also affects how exempt employees are paid. But it's not as cut and dry. This one kind of gives you a little bit different calculation. So the healthcare minimum wage says for your exempt employees, you have to pay them either 2 times the state minimum wage, which is at $16.90, that leads to $70,304, or 1.5 times the applicable healthcare minimum wage. You have to pay them the higher of the two. So if you're in the healthcare field that has seen this minimum wage increase and you have exempt employees, make sure you do both calculations to see which one is going to apply to your exempt employees. That way you're paying them correctly. So a little bit more about this, as I mentioned, the increases are gradual. So some of the larger hospitals, the larger healthcare systems, they are going to hit that $25 number July 1st of this year. But as you can see, some other ones are not quite there yet. So they're a little bit lower down the scale as far as that gradual increase goes. So safety net hospitals will be at $19.28 effective July 1st. Community or rural clinics, a little bit lower than that. And then you have all other covered employers not run by counties at $23 per hour. Again, if you're not sure which one of these categories you fall into, take a look at that bit.ly link we saw earlier, or give us a call on the hotline. We can kind of help you work through it to see which category you are going to fall under. Now, another increase we saw coming in here at mid-year is the one for mileage reimbursement. So typically, the IRS doesn't adjust its mileage reimbursement until the end of the year and makes it effective on January 1st. However, we are seeing a mid-year increase take place this year. This took effect July 1st, and it increased from 72.5 cents a mile or 72.5 cents a mile up to 76 cents per mile. So it's a pretty drastic increase. Not sure if it's related to the increase in fuel prices or anything like that, but again, make sure that if you have employees that drive their personal vehicles for business purposes, you are compensating them correctly because that has increased as of July 1st. Now, something else to keep in mind too is if you are paying your employees mileage for driving their personal vehicles for you and they are non-exempt employees, in other words, they're hourly, they still have to be paid for their time aside from the mileage expense. So the mileage calculation only takes into account fuel, wear and tear, maintenance, insurance costs, that sort of thing, but it does not take into account the employee's working time. So you still have to be compensated on top of that mileage reimbursement. So again, make sure that you are paying the correct minimum wage at that, or I'm sorry, the correct mileage reimbursement. And if you have any kind of outside company that does those calculations for you or that does those the reimbursements for you, make sure that they are using the correct rate effective July 1st. Now, when it comes to OBA or HR1 or One Big Beautiful Bill Act, whatever you want to call it, um, again, some of the very publicized portions of it was there was going to be no tax on tips and no tax on overtimes, and those were going to be effective. Basically, they said they're effective as of March of last year. So as of 2025, this law passed mid-year, and it said, this applies to this year. So we had a lot of calls from employers telling us, well, what do we have to do? What do we have to do on our end? Do we have to do anything? Do we have to, change the way we report things? So the good news is for 2025, there was almost like a grace period, right? The government said we recognize that we passed this mid-year, so we don't expect everybody to kind of go back and recalculate all the tips and recalculate all the overtime for the year and report at the end of the year. So they allowed employees to kind of report an estimate as to what their qualifying tips or qualifying overtime was. But effective this year, since 2026, employers will have the whole year to track and report this. They need to report the qualifying tips and qualifying overtime to employees at the end of the year. So in other words, you have to have different note or section in your W-2 that reports this, or give some kind of document to your employees that shows them what their qualifying tips or qualifying overtime were, so they could take that tax deduction next year. Now, when it comes to tips, those are defined by the IRS as far as which industries can apply that deduction, right? So it's not just for everybody. I can't just say, well, you know what, I'm a mechanic, and I'm my customers tip me all the time, so I don't have to report that, or I get tax deductions or whatever. No, the IRS says, this only applies to certain occupations, and they have a list of about 70, more or less, occupations that can use that qualified tip deduction. So if you're not sure if it applies to your industry, take a look at that IRS page. But again, anything from beverage and food service down to transportation delivery are qualified to take that that deduction for any qualifying tips. Again, most of them are the traditional ones that we could think of, right? Food service, hospitality, personal services, recreation, that sort of thing. But again, if you're not sure if it applies to your industry, take a look. Now, something else to keep in mind too is that for tips to be qualified tips, they have to be paid voluntarily by the customer. So in other words, some of us have had the experience where we go to restaurants and we're in the big party and they automatically add on a service charge or a tip at the end. Since that automatically is added on and it's not something that we're voluntarily given, that would not be a qualifying tip. So it has to be something that the customer pays voluntarily and is not obligated to pay. And again, the deduction is only available for any tips that are reported on a W-2. So I, as an employee, cannot just pull a number out of the air and say, I was tipped $8,000 last year, and it's not on my W-2, but I'm going to take the deduction for it anyway. So all tips that are going to be deducted for tax purposes have to be reported on the W-2, 1099, or on Form 4137 for employees. The other side of this deduction applied to overtime, right? And this was a biggie. This was a big selling point for OBA, and it came out, and a lot of people thought, oh, well, my paycheck's going to be bigger because my overtime's not going to be taxed. That's great. I'm going to be taking home more money or what have you, right? And that's not actually how it works. Again, what OBA does is it allows a deduction for qualified overtime. So you don't see the benefit of it until the following year when you file for your taxes. You can deduct any qualified overtime for tax purposes. And the thing to keep in mind too is that California overtime is a little bit different than federal overtime, right? When it comes to federal overtime, it's any hours over 40 is overtime. And that's it. Pretty cut and dry. California is a little more generous, of course. California says, well, you can get overtime for any hours over 40 and for any hours worked over 8 hours in a day. On top of that, we have our own rules when it comes to double time that are more generous than the federal law. But since OBA is a federal bill, it only applies to qualifying federal overtime. So that means that any of that overtime that's paid for working more than 8 hours in the day may not necessarily qualify for that deduction. The only thing that qualifies is any overtime paid for working over 40 hours in a work week. So unfortunately, if you're doing payroll in-house and you're figuring out the tax for that W-2 reporting, it is going to be a little more complicated than just taking the full overtime for the year. You have to see if it actually applied or if it's actually applicable and qualified because it goes over 40 hours in the work week. So again, only weekly overtime qualifies for that deduction, not California's daily overtime or not that seventh consecutive day overtime in California. So again, makes that reporting a little more complicated for us employers here in the Golden State. Finally, another change that we saw come through, and this one was due to a court ruling from the Ninth Circuit Court. This one deals with meal and rest break penalties, and this is pretty industry specific. This one deals really with any commercial drivers that transport passengers that are involved in interstate commerce. And if you have any DOT or federally regulated drivers, you know that their meal and rest breaks are a little bit different, right? They don't necessarily have to comply with that 5 hour rule that we have in California for taking that meal break. Um, and so the court extended this to any interstate drivers that transport passengers. Again, it's kind of a niche little ruling, doesn't apply to everybody across the board, but it just goes to show the importance of knowing that if you have any drivers or workers that are federally regulated, in other words, that fall under the Federal Motor Carrier Safety Administration's control, know that their meal and rest breaks may be a little different, and the California's regular meal and rest break rules may not apply to them. So to wrap up this first half before I hand it over to Astrid, some to-dos for you for wage and hours. First one is make sure that you adjust those pay rates to reflect those local and industry increases. If you have employees that are working in certain areas that are affected by those minimum wage increases or in certain industries, make sure that you adjust those salary or those pay rates, those hourly rates as of July 1st. Um, that also means that some of the postings are updated, right? We have that minimum wage posting on our labor law poster. So a lot of these counties or cities that have different minimum wages or minimum wage increases are going to publish these on their website so we could download them, print them up, and post them correctly. So make sure you update those as well. And make sure that if you have employees that work in different locations, different municipalities that could have a higher minimum wage, that you have a way of tracking that so that your payroll system or payroll person can pay them correctly. And also, if you have any employees that receive tips or that work overtime, make sure that those are tracked and reported correctly. Work with your payroll provider, with your payroll person to make sure that you're tracking them, hopefully on a payroll period basis rather than trying to figure it out at the end of the year, so that you can report them correctly to the employee for the tax year. That brings us to the end of the first half. So with that, I will hand it over to Astra. I know she's been busy over there in the Q&A.
Yeah, we actually have a couple things while I get this
Sure,
started. If you want to
of course.
clarify mileage a little bit, we had quite a few
Uh-huh.
questions on mileage.
hmm
So if you can let us know, some employers are saying they pay after a certain amount of miles. Also clarity
hmm
on exempt employees and how they should also still be not necessarily the commute time, but because we talked about both commute time and mileage. But if
Sure.
you could clarify a little bit on mileage, that would be great. While I
Yeah. Yeah. So I mean, basically, under California law, any expense that the employee has suffered has to be compensated by the employer if it's for the benefit of the employer. So having someone drive for you basically is to the benefit of the employer. So you have to compensate them according to that IRS rule. So the IRS says, this is our calculation as what the minimum cost is for the employee using their own vehicle. So make sure that you're paying at least that 76 cents or wherever that increase is. Um, Now, that's not something that necessarily says, that you can say, well, the first 5 miles are free, and then after that, we're going to pay it out. If they are doing any kind of work for you in their vehicle, they have to be compensated for it. And as Astrid said, this doesn't include commute time, right? Commute is just a regular part of work. It's not something that has to be compensated. But anything beyond that, where they're using their vehicle, say if you ask them to run out and pick something up for you, pick up lunch for the office, or go drop this off at a client's house or whatever, that is all wear and tear on their vehicle. That's using fuel, so that should all be compensated according to
Mhm.
that mileage. If you're going to pay anything less than that, it's up to you to justify why you're paying less. So in other words, if you're giving them a fuel card or something like that on top of it, you can use that as justification, but just be ready to defend that because to be honest with you, I mean, when we see wage and hour claims or claims for, for lack of expense reimbursement, that's usually a lot of the times where employers get in trouble not paying employees correctly.
Right. Thank you. Thank you
Mhm.
for that. And yeah, you can pay less than the IRS, but as Eli said, then it's the employer's burden to prove that it was sufficient. And if something were to happen, we can easily justify the labor commissioner has come out to say that the IRS rate is what they go off of. So if you're using that rate versus a lower rate, then you're in the good, you're in the green.
Correct.
But if you're not using that rate and you choose to do a lower, you're still in compliance, but you're going to have to, if there is a claim, you're kind of taking a gamble, then it can be where you'll have to prove that that was sufficient. And if it wasn't, you might be on the hook there.
Right, right. Absolutely.
All right. Well, thank you, Eli. That was all a lot of good stuff on pay and wage and hour. So we're going to switch topics completely now and talk about, if I can get my screen to work here, artificial intelligence. So at the moment, this is a big buzzword, a lot of buzz around this topic, but actually there's not a ton of laws yet. So as you know, we all like to say we're not keeping up as fast as AI is changing. And so as soon as we have regulations or laws, sometimes they're just not keeping up with the way AI is going. So we still have a few things, however, that we want to talk about. There was a law called Senate Bill 7 last year that was going to create some burden for employers, a lot of work for us, but that didn't go through. However, the legislator is trying to revive that and make it so that we see a lot more bills and a lot more laws that will affect employers in the future for sure. Not there quite there yet, but just know that that's something that the legislator is working on. We do have one area that we're going to talk about, and that's regarding our Civil Rights Department. Our Civil Rights Department has some focus and has passed some regulations when it comes to discrimination, potential discrimination claims when using AI tools. So that's what going to be our focus today. And because AI is just taking off at rapid speed in our workforces, we're going to talk about drafting your AI handbook policy. So I kind of want to know from you, I'm going to take a poll here. And if I can find my poll button, does your company use AI tools to screen resumes to help candidates? Let me know. I don't know if I have that one. So just let me know in the chat. If does your company use AI tools to screen resumes or help select candidates? Yes, no, or we are thinking about it. Let me know. Yes, no, or we are thinking about it. What does it look like for you? So most of you are saying no. So maybe smaller employers, some of them saying kind of not yet. Possibly, maybe you have a recruiting department or you have your HR department who's doing it and you're unsure. And if you are using any sort of Indeed or any kind of platform, then you're likely using AI without realizing that you're using AI to screen your applicants. Yeah, so some people are saying Indeed and some people are working through it. So this is a good time to review this information. So the Civil Rights Department, that's our government agency in California that tells us we have to do harassment claims or discrimination training. It's also where our laws come from for harassment discrimination. They also deal with things like pregnancy disability leaves and all kinds of other things. So our Civil Rights Department issued regulations to protect against discrimination when companies use these, what we call ADS, automated decision-making systems, including artificial intelligence tools for employment decision. And so they're doing this because we want to protect applicants and employees from discrimination. And it's usually inadvertent. We're not really purposely doing this, but it's maybe weeding out people that we don't mean to. And so this new regulation clarifies that the employer is responsible for ensuring that this tool they're using or the platform they're using is not discriminating, whether it be intentional or not. This has already become effective in October of last year, October 1st of 2025. So this applies to all employers. The regulations clarify that California's anti-discrimination laws apply to these systems that we're using. So both employers as well as any third party that you're using that sell automated decision making could be held liable. So we want to make sure that the tools that we're using, the platforms that we're using, the headhunter that we're using, the recruiter, that they are aware of this law that went into effect October 1st and that they are doing their part in having a human touch in this area. So just to dig in a little bit further about what is defined by law, what is an automatic decision system? It's any computational process that makes a decision or facilitates human decision making through artificial intelligence, machine learning, statistics, or other data processing techniques. So if you're using things like this, even as an employer to help your business or to help customers, it's going to impact all these areas here. So we need to be aware, not just for recruiting, but anytime that this ADS is making decisions for our company. So this artificial intelligence is just one area that falls under this larger ADS umbrella. So again, gaining a lot more popularity. Make sure that any system that we're using, any platforms that we're using to get statistics, any kind of machine learning about our customers, about marketing, things like that, that we're looking at it through the lens of an ADS. Okay, so our Fair Employment Housing Act, so that's the law that says we cannot discriminate against people, we cannot harass against people. Well, this law applies when employers use these AI tools or ADS to assist in making these decisions to hire people. And so whenever we're using it to hire, probably less so we're using it to use for promotion purposes, but maybe we're using it to select what kind of training programs, especially if you're a bigger company. I don't think I have a lot of huge companies here, but if you have a huge workforce and you're using this as to look and see what who I'm going to train, what departments, and you're using AI, let's have a human touch and a human element. If you're using platforms to look at whether I'm compensating employees correctly, that is also using AI, and we need to make sure that that has a human element touch to it as well. A discharge or other term conditions of employment, probably again using that a little less in that area. Most people on here are probably using it to hire, using some sort of Indeed or platform that's using that. But even things like computer-based tests or quizzes and games should be job related and consistent with business necessity. So if we're using these tools to help with assessments or measure skills or assess personality traits or aptitude, we need to be careful, okay, on those. We cannot use ADS or AI tools to inquire about criminal history either prior to a conditional job offer. And I think that we're good on that, right? We know, just a refresher for criminal history, we cannot inquire about an applicant's in criminal history unless we've made a conditional job offer. So doing that prior to that would be against this policy as well as others. And then record retention. If you are using AI and platforms to screen applicants and you've had the human touch to it, so you know you're not discriminating intentionally, we do need you to keep those records for 4 years from date of creation or personnel action, whichever comes later. So let's make sure that we're also keeping all those records related to any hiring decisions, all that. That record retention one, when I do audits at member sites, that's one that always gets me, because a lot of employers are not tracking those applications and things that they're using for making decisions on filtering out who they're going to interview. If you're using those tools, we need to keep those for 4 years. So be aware of that. Let's look at a real world example of, already we're seeing some of these. This is a gentleman named Mr. Mobley. Used a platform very similar to Indeed called Workday, and he applied to over 100 positions with different companies through their hiring platform called Workday, and he was rejected 100 times. Every single time he was rejected. Well, Mr. Mobley alleges that Workday's AI hiring tools disadvantaged him and other job seekers because he happened to be over 40, and he found this is probably the case. Workday is filtering us out, those of us who are over 40. And this became a lawsuit that is now a collective action lawsuit, meaning that others can join him. So it has been approved for it to be a collection action lawsuit where others can join him that are similarly situated, that are over 40, very similar to a class action lawsuit, if you're familiar with those. So definitely something that we need to look out for, because this is becoming a lawsuit that is active. It's still in the works, but it provides insight into the risks of using AI tools in recruitment and making these employment law decisions. So this is very fresh. This is May of 2025, where a judge actually granted preliminary certification that allowed this group action lawsuit to continue. So right now it's Mobley and 4 other plaintiffs, and they're all over 40, all very similarly situated. And so if the court has to determine whether that main issue, whether that Workday AI system disproportionately affected applicants who are over 40, and that can be addressed collectively. So if you use Workday yourself and you're over 40, you may be getting one of those notices that says, would you like to opt in on this? So definitely more to come on this one, but I'm sure this wasn't something that maybe was intentional, but something in that platform was used so that it caused this inadvertent discrimination possibly. All right, I know we're active in the chat and the Q&A. I know Eli is on there, but I do have a poll for you about AI. And this is, do you have an AI policy in your employee handbook? I'm just curious whether you've implemented one, and you probably did if you've updated your handbook in 2026. And if you haven't done it, maybe you haven't gotten around to it, maybe you're working on it. So just go ahead and let me know. Mostly out of curiosity, we're looking to see what our employers out in California are doing. I know in our own employer handbook at CEA, we have included an AI policy, and when we help employers draft these employee handbooks as of 2026, that AI policy comes standard unless you want to remove it, because I realize there's some of you who may not be using it as much. So I'm going to go ahead and end the poll here and share the results. Most of you do not have an AI policy. Some of you are working on it, and a very smaller minority of you are I already have one. So that's great. So let's review it and see what we should be considering when you're drafting your A policy. I'm going to recommend it because you may not realize how much your employees are probably using AI, even if your workplace isn't one that is conducive to one where we're telling employees to use it. They still may be logging on to ChatGPT to check on things. So some key considerations: define what that ADS means for your company. Identify what that means. For example, you may decide that your HR management team can't use AI to facilitate employee-related decisions. Or maybe also, and who's allowed to use it? Is it permitted for everyone? Is it just our management team who can use it? Is it restricted to only certain types of work that we do? So who is allowed? Which employees are allowed and authorized to use it? Maybe it's everyone. Everyone is welcome to use AI as long as you use it responsibly under these parameters. What can't go in? Maybe we are going to define that we cannot put sensitive personnel or customer data or trade secrets or business documents, sensitive HR legal stuff. That can't go into a ChatGPT. We cannot be copy and pasting our customers' private information into that. And this is why the policy is very important. And then your work product, ensure that if they are using, maybe you do authorize, like we're allowed to use some sort of AI at some point, but we have very strict parameters of when we can use it and how we can use it. And we need to ensure that the quality and accuracy of work by verifying information and sources. So as you may know, a lot of times it's wrong if we're using certain software systems, and sometimes it doesn't get it right. And I just this week have gotten calls from 2 members where they were calling in to check because they weren't sure if the ChatGPT answer they got was correct. And lo and behold, it was not. One was not as detailed enough, so we needed to go through the information. It was a leave of absence question. And the second one was, what was it? Because I was going to use it in today's example. But the other one was regarding, I remember, it was mandated reporter training. So employer calls saying we need mandated reporter training. It doesn't apply to us, right? Because it's only for schools and for healthcare, and it doesn't apply to all employers, when in fact it very much does. Assembly Bill 1963 changed in 2021, but the ChatGPT wasn't looking at that year that far close to us. They were looking further back and spit it out an answer that was incorrect. So he called us in to ask, was this accurate? And it was not. Mandated reporter, just so you know, has to be done for anyone who's hiring minors now. So, other helpful provisions, policy violations cannot be used for harassment, deception, or fraud. And there's already a case on this one where an employee used AI to create an AI image and used it to sexually harass someone. So it was a nude photo of an LAPD captain, and that was used and circulated among coworkers. It was a fake nude. It was, again, AI generated. And they were awarded $4 million. A jury verdict found that that falls under our laws against visual harassment, even though it wasn't a picture of her specifically, it was an AI generated. It was, these AI generated sexually explicit deep fakes, altered image, whatever you want to call it, they protect an individual's trait. So it is legally satisfies that threshold for visual harassment. Privacy and property rights, any work that's generated by AI for business purpose is company property. So if you are using it as a tool to assist you with something, that becomes company property. So making a statement of that would really be helpful for you. And then we reserve the company's right to monitor those AI systems as well. And then include that EEO statement, employer commitment to not using AI in a discriminatory manner, record retention for any employment related issues. If you're a CEA member, we do have that customizable AI policy available under our HR forms. So some takeaways from this section: familiarize yourself with how AI may already be part of these HR tools and in your work environment. Ensure there's always a human touch, a human element to that AI process and your record retention. Consider how employees may be using AI already. And so maybe look into whether you should be having a policy. And I'm going to say yes, have a policy, you never know. And then monitor legal developments and use of AI. Follow us at CEA. We do blogs about this all the time. And as I said, as laws change and they are changing or keeping up, then we will publish them. Moving on to a different topic here is our training obligations. We just want to remind you of this because we do need to do this one annually, and that's the Workplace Violence Prevention Plan. We're required to train our staff annually for that one. And we, as a reminder, need to solicit employee feedback and review those, any kind of update that you might have. If something was triggered because there was an incident, that needs to be reviewed as well. And it's the deadlines for that is when that is established. So you need to train them when you establish your plan for workplace violence prevention plan. And then you need to do it anytime you identify a hazard or make a change to it, and then annually as well. And typically that's in July because a lot of people started their plan and implemented it in July when the law became effective. And then just as a reminder of harassment prevention, which is biannual, meaning once every 2 years, a reminder to train those employees every 2 years, 1 hour for employees, 2 hours for supervisors. Reminder that it needs to be interactive. You can't just pop in a video and have them watch it. And it does need to be with someone who's knowledgeable on those laws on harassment. If you have temporary employees or seasonal employees, then you must train them, provide that training within 30 calendar days after the hire date, or if you're only hiring them for 2 weeks, it needs to be done within that 2 weeks, whichever comes first. So within that time that they work. If you are promoting someone to a supervisor position, you have 6 months to do that training as well. So these two can easily go hand in hand, by the way. I've gotten, again, another call about this week where the harassment prevention training that they did was great, but they had an incident that occurred where they were arguing and upset with each other. These are two managers who are always upset with each other, and one slapped the other one on the behind, not necessarily in a sexual manner, but in an upset manner, and not in a violent manner, according to him, but it was not taken as in a friendly way. And so that triggered our workplace violence prevention plan. It also is triggering the harassment plan. It needs to be investigated under both lenses and needs to be reviewed under that workplace violence prevention plan. So, just a kind of an example of how the two can work hand in hand sometimes. Okay, a little bit of notice here as we end our labor law update mid-year. Labor law posters and notices that we need to be aware of, and always stay up to date. That blog I talked about, if you go to employers.org/blog, you can subscribe to our blog and we keep you updated of anything that might be new, anything that laws are changing. But some updated postings for right now, the Cal OSHA Safety and Healthcare Protection on the Job. It's available in English and Spanish, and that became effective April 2026. Also, the EEOC Know Your Rights. It's marked as undergoing a revision currently right now. So we're okay there, but we do have that one that was already published that you could be using. And then the annual notices to distribute, the EITC sent with that W-2. There's a second notice in March that we're required to provide. And the Workplace Know Your Rights notice, that one we give at new hire. It's part of your new hire paperwork. But that one we have to also do annually. So don't forget that. We have to do that annually where we give that to our established workforce. And same with the crime victims notice. If it's in your handbook, great, but we also need to provide it to employees on an annual basis as well. So more and more we're having notices that we need to distribute annually. So just keep a tickler on there, a calendar of what we need to give to employers. And these notices can be provided by handing them directly to the employee. We can mail them. It's not compliant to simply post these specific notices through a bulletin board or through an employee handbook. These specific notices. Some of the other ones that are in your handbook are fine, but these ones we have to actually either mail or give to them physically. They need to have a copy of that and then have proof that you sent it. So some notice and training to-dos, ensure all your postings are updated. If you order that all-in-one poster every year, you should be okay because we don't update those until the laws change. So if you have one of those, great. If you need one, just visit our store. We have them available to you. Distribute annual notices and audit new hire paperwork to make sure we have all the proper paperwork. You can go to employers.org and find a free new hire checklist if you'd like, if you need that. And complete that workplace violence prevention plan annually. We do need those employees to be trained annually. And then make sure your harassment prevention training is up to date for all employees as well, and that you're doing it by the training year you're supposed to do it on. All right. To end here our section, we're going to look at some case law and some federal updates because they kind of give us an indication of what to be on alert about. So this is a good way to kind of know what's on the horizon, what might be coming, or what's the focus of the day right now that we should be paying attention to. So let's talk a little bit about whistleblower laws, something we don't talk about all the time, but when an employee complains about conduct that isn't actually illegal, do those whistleblower protections apply? And those whistleblower protections, the law on whistleblower is on those posters. So if anyone's reading those posters on the all-in-one, that's a big section of it. And the answer to that is yes. Even when an employee is mistaken about the law, as long as their belief was reasonable, they will have a whistleblower case. This was a case, Contreras versus the Green Thumb Produce. And this was a forklift operator who thought he wasn't getting paid correctly, as far as he felt like his coworkers were getting paid higher, senior employees were getting paid higher for similar work. And he cited the California's Equal Pay Act from the Labor Commissioner's website and went to HR and said, I think you're violating this law and I'm upset about this. Well, the HR manager said, denied his request for a raise and said that he shouldn't be showing that Labor Commissioner's information to everyone in the workplace. And they subsequently fired him the next day, citing various different acts like insubordination. But he sued them. He sued Green Thumb and said, under the whistleblower law, and said, I thought that this applied to me, and so I went to them thinking that this applied to me. It did not apply to him. The Equal Employment and Equal Pay Act applies to discrimination based on sex, race, or ethnicity. And Mr. Contreras actually said, I just thought that other people I didn't think it was because of my race, sex, or ethnicity. I just thought it was because they were getting paid more than me. So the law didn't apply to him, but he had a reasonable belief that it did. And so when he sued, the courts found that it was reasonable for him to think that that was a protection, and those whistleblower laws applied to him, and they cited in his favor. And so the takeaway here is that when an employee complains to you, even if it's not right, it's probably not harassment or not whatever violation they're thinking it is, you should still be professional about it, still take it seriously, and go through the the process. Don't terminate them the next day because they filed a complaint. Even if it's not a protected reason they're coming to you for, we're still going to keep it professional. Another one here, reasonable accommodation. If an employee never discloses their disability, when is it assumed that the employer has knowledge of the disability and therefore must engage in the interactive process to determine if there are reasonable accommodations available? So is it our responsibility to just guess if an employee has a disability or not? And the answer to that is if an employer is not notified by the employee or a third party directly, they will be considered to have knowledge only if the employee observes conduct that leaves no reasonable interpretation other than disability. So if we in fact can visually tell or observe that there's no reasonable interpretation other than disability of what's happening, then it's our duty and our responsibility. Otherwise, hey, if they didn't disclose it and didn't ask for an accommodation and didn't know, then it's not our job. Here's an example. Because this is an actual court case that came out. It's Husband versus Target. The employee was terminated for violating the workplace violence prevention policy. It was actually a very scary event. There was some erratic behavior. He used profanity. He was yelling at other employees, questions about whether his supervisor had killed coworkers, and comments about inanimate objects laughing at him. He had bipolar disorder, but did not inform Target until after termination. The supervisor was genuinely concerned about his mental health, but Target was found not liable for discrimination or failure to engage in the interactive process. The employees tried to say that, hey, you should have known I had bipolar and you should have seen that I had mental health issues and you should have engaged with me in the interactive process before firing me. But in this case, which was a great takeaway here, Target was found not liable. So the takeaways here is employers' observation of unusual behavior, not always enough to indicate knowledge of disability, but be aware when it does. So if someone is having frequent seizures, for example, or they've told you about a known, this changes the game. It's not going to be under the same lens here. So be aware of that as well. I know I'm at 11 o'clock. I'm going to keep going. Hopefully you all can stay on with me. I just have one more area to cover, and that's the I-9 requirement. This is becoming, again, a very hot topic and something that's coming up. So we want to make sure we cover it. Employer receives a notice of inspection for I-9, and they have some minor things that are missing. They're kind of doing a quick audit of their I-9s and realizing, shoot, we missed the date of birth, we missed the date of hire. Is this a big deal? And the answer to that is that yes, it is a big deal. There's an increased penalties. This changed as of March 2026. ICE changed guidance to consider these to be substantive I-9 violations. So if you are missing date of birth, missing date of hire, they were probably not seen as a big deal. Well, they are a big deal right now. Failure to complete your USCIS number, missing date in Section 1, just a simple date, like you missed the date. Failure to print the name and title of the employer, authorized reps. Eli and I do audits like this a lot, and we see this. We see people who didn't finish correcting the I-9, didn't finish auditing them or substantiating documents, missing date of hire. So not just that you didn't do it right, you just failed to miss those little boxes. Well, these are substantive I-9 violations now, which means the penalties are much higher, from 288 to 2,861 per violation. So make sure that you're auditing those I-9s that you're providing. When you get that notice, you typically have some time. I think it's 72 hours to actually before you actually have to turn them in. That's the time to check them, right? We're going to check them. Well, hopefully check them before, like now that you know, and audit those. And if you're a member, we have an I-9 toolkit that will help you, but definitely spend some time making sure that you capture those things before they become significant penalties for you. So thank you for sticking with us. Just to wrap up, make sure you audit those minimum wage mileage increases, keep up with them as they go up in July and then again in January of next year, that you're doing those tips and overtime to report those to your employees. If AI is your thing and it's something that's impacting your workforce, that you're spending time building that policy, you're distributing those annual notices, keeping up with those trainings that you need to do. And as a reminder, again, audit those I-9 forms and monitor legal developments because keep up with that. And again, stay with us on our blog so that you're aware of what's going on. Anna, that was a mouthful, and we covered that in just 2 minutes over. So Go to your partners there at the Workforce Development. They're fantastic. And, we really love that partnership with them. I know I used to use them when I was in the field, and I'm from Redlands, and I use them in Redlands. So great testimony there of the work that they provide. Back to you, Anna. Thank you so much.
Woo, Eli and Astrid, that was a lot of information in not a whole lot of time. So thank you for making that such a comprehensive training and getting that all in there. Like we said, we appreciate you staying a couple minutes over with us. This is being recorded, so not to worry if you have to jump off, not to worry. If you need a little more, here's a little more information about membership options. I know we mentioned that, a couple of the resources that we provided are exclusive to members. Marcia, the PowerPoint, I did put it in the chat. Let me drop it in again for you. What's the next slide, my dear? Is that the...
Oh, sorry, there's the survey.
You're all right. You are all right. As I mentioned at the top of the hour, if you're able to help us continue to help you, the best way to do that is by hearing directly from you. So if you can either scan that QR code, and Marcia, I'm dropping that link in the chat, or I'm sorry, the PDF in the chat right now. There's also, if you scroll up a tiny bit, I did drop a link to share your feedback, so you can choose your own adventure, but we would love to hear directly from you. That's how we continue to develop these trainings to serve you the best. And then if you are here for continuing education credits, your code is on the screen as well as in the chat for your convenience. HRCI code 748095, SHRM code 26-AYYPZ. Message Eli if you want something cute done with that acronym there for you. He's always got something creative for you. Call in the HR hotline. But with that, again, thank you for your extra time and just your time in general spending with us today for this really important training. Thank you, Carmela and Desiree, for all that you and your hardworking team do to provide for employers and HR professionals in the area. And we really look forward to seeing you in August for that leadership training, Be a Leader, Not a Boss. It's a really, really powerful training that we hope that you register for today and then share it with your colleagues and your team accordingly. So thank you all for attending today. We look forward to seeing you next month, and look for an email from our team or San Bernardino with the link to the training, to the recording, as well as a PDF of the slide deck. Thank you all. We'll see you again next month. Cheers.
Good job, everybody. Good night.
Thanks, Carmela.